Warm greetings to everyone. I am Riya Kaushik, BCom Honors LL.B, Intern at ubAdvocate under the guidance of Respected Advocate Jeevan Prakash, AOR, Supreme Court. I will discuss with you all the guidelines issued in the case of Vishaka and others versus State of Rajasthan. There were several important guidelines issued by the Honorable Court for the prevention of sexual harassment of women at the workplace. The first is the duty of employer or other responsible person in workplace and other institution. It shall be the duty of employer or other responsible person in workplace or other institution to prevent or deter the commission of acts of sexual harassment and to provide the procedure for the resolution, settlement, or prosecution of the acts of sexual harassment by taking all the steps required. The second guideline provides a definition which covers the sexual harassment definition, which includes the physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, and any other unwelcome physical, verbal, or non verbal conduct of sexual nature. The third guideline includes the preventive steps which the employers or person in charge of the workplace should take. All the employers or person in charge of the workplace, whether in the public or private sector, should take appropriate steps to prevent sexual harassment. Without prejudice to the generality of this obligation, they should take following steps. Express prohibition of sexual harassment as defined above at the workplace should be notified, published, and circulated in appropriate ways. The rules regulation of the government and public sector bodies relating to conduct and discipline should include rules regulation prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. As regards private employers, steps should be taken to include the enforced prohibitions in the standing orders under the Industrial Employment Standing Orders Act 1946. Appropriate work conditions should be provided in respect of work, leisure, health, and hygiene to further ensure that there is no hostile environment towards women at workplaces and no employee woman should have reasonable grounds to believe that she is disadvantaged in connection with her employment. Fourth is criminal proceedings which can be initiated against the offender. Where such conduct amounts to a specific offence under the Indian Penal Code or under any other law, the employer shall initiate appropriate action in accordance with the law by making a complaint with the appropriate authority. In particular, it should ensure that victims or witnesses are not victimized or discriminated against while dealing with the complaints of sexual harassment. The victims of sexual harassment should have the option to seek transfer of preparator or their own transfer. Fifth is disciplinary action which should be initiated by the employer. Where such conduct amounts to misconduct in employment as defined by the relevant services rule, appropriate disciplinary action should be initiated by the employer in accordance with those rules. The sixth guideline is the complaint mechanism. Whether or not such conduct constitutes an offence under law or a breach of the service rule, an appropriate complaint mechanism should be created in the employer's organization for redress of the complaint made by the victim. Such complaint mechanism should ensure time-bound treatment of complaints. Seventh is regarding complaints committee. The complaint mechanism referred to in sixth guideline above should be adequate to provide where necessary a complaints committee, a special counselor or other support service include the maintenance of confidentiality. Further, to prevent the possibility of any under pressure or influence from senior levels, such complaints committee should involve a third party, either NGO or other body who is familiar with the issue of sexual harassment. The complaints committee must make an annual report to the government department concerned of the complaints and action taken by them. The employers and person in charge will also report on the compliance with the aforesaid guidelines, including on the reports of the complaints committee to the government department. Eighth is workers' initiative. Employees should be allowed to raise issues of sexual harassment at workers' meeting and in other appropriate forum, and it should be affirmatively discussed in employer-employee meetings. Ninth is about awareness. Awareness of the rights of female employees in this regard should be created, in particular by prominently notifying the guidelines and appropriate legislation when enacted on the subject in suitable manner. The 10th guideline is about where sexual harassment occurs as a result of an act or omission by any third party or outsider. The employer and person in charge will take all steps necessary and reasonable to assist the affected person in terms of support and preventive action. In the 11th guideline, the central state governments are requested to consider adopting suitable measures, including legislation, to ensure that the guidelines laid down by this order are also observed by the employers in the private sector. 12th is these guidelines will not prejudice any rights available under the Protection of Human Rights Act 1993. Lastly, the Honorable Court said that it is directed that the above guidelines and norms would be strictly observed in all workplaces for the preservation and enforcement of the right to gender equality of the working women. These directions would be binding and enforceable in law until suitable legislation is enacted to occupy the field. Thank you so much for watching. Have a nice day.